Welcome to Divorce Connection Network. I am your host, attorney Tammy Saltzman, and I am so excited today to introduce you to attorney Charles Cohen of the prestigious law firm of Furr & Cohen, located here in Boca Raton. Welcome, Charles.
Thank you, Tammy.
So good to have you here. And Charles works with Robert Furr, one of my favorite guys in town. And Charles and I work together on collaborative divorce. And we are working together on a training in June, which we're going to hear more about as the show progresses. And today, we are going to talk to Charles about his specific area of expertise, which is family law and bankruptcy. So some lawyers have a dual practice. So you practice family law and bankruptcy. Is that correct?
Correct. I started out as a family lawyer, and then probably 20 years ago, my partner Robert said, I need help. So for the last 25 years, I've been doing bankruptcy work as well.
And you've been practicing for over 40 years, is that correct?
That's correct.
So you're a very seasoned attorney. Someone that I go to when I need help. Okay, so this is what I want to ask you. And bankruptcy can occur in a divorce situation. Quite often, bankruptcy is the reason that people sometimes get divorced. The financial stress and pressure wears on a marriage. Is that correct?
There's no question that many divorces are caused by the financial pressure.
Okay. So when a couple is feeling that financial stress where their liabilities greatly exceed the assets of the marriage, and they are feeling this pressure, should they consider filing bankruptcy before they get married or after?
Well, that's a little complicated question, but you have to understand that if the couple come into me together, I can only represent them as a couple. I would not be represent one as opposed to the other. And if they come, usually in a case like that, they've been referred to me by their divorce lawyers, and who have called me and I said, listen, you need to consider bankruptcy. If you file the bankruptcy prior to the divorce, there will be no debt in most cases. If you don't, the problem that you have is that if they go ahead and get divorced, whether it's settled or not settled, many times you will have the husband who has all this debt, and he says he gets rid of the debt by bankruptcy, but a divorce judge could say to the wife, we're going to split the liabilities equally so your husband still has half the debt. And he will have just gone through a bankruptcy for nothing.
Right, because then once he gets divorced, whatever debt, it gets shared.
Correct. There are some problems with doing a joint bankruptcy prior to the divorce, and it's an area called the means test.
Means test, okay. And so what is the means test? Why don't you tell us that?
Congress changed the bankruptcy laws somewhere between probably close to 10 years ago, and they developed a means test to force people into a Chapter 13. Now, understand there are different chapters in the Bankruptcy Code. Chapter 7 is a liquidation. Chapter 11 is a corporate or individual reorganization for people with substantial assets and substantial debt. Chapter 13 is what we commonly refer to as a wage earners Chapter 11 reorganization, but it's called Chapter 13. If someone wants to file a Chapter 7,
which erases all the debt,
they have to pass the means test. In other words, they have to have an income that's not too high, because if it is too high, then they're forced into a Chapter 13, which is paying their debts, paying a percentage of the debts over 5 years.
Okay.
The means test, the difference if you have a couple, both incomes are included in the means test. Whereas if you have just an individual filing Chapter 7, and he's divorced, it's only his income.
Okay.
Unfortunately, even if they're still married, he's just filing her income or his income is included in the means test.
And the means test is a calculation based on what's owed and how much they earn?
No, No, it's similar to if someone wants to do an offer and compromise with the IRS, it's similar that the IRS takes your income, and it's the same situation here. They take your income, they put it in a set of schedules, and they sit there. Here's what we will allow. We will allow X dollars for a car. We'll allow X dollars for medical. We'll allow X dollars for the housing. Usually, if there's a mortgage payment, they're going to allow the whole mortgage payment. But they will allow certain expenses, and there's a schedule of what they will allow. And when you meet with a bankruptcy lawyer, he just can't tell you off the top of his head, based on income, where the means test is going to come, because you have to fill out this schedule on your living expenses, and certain living expenses are allowed, and certain living expenses are not allowed.
Is it discretionary or is it statutory?
It's statutory. It's in there.
Okay, so it doesn't matter who you end up in front of or what lawyer you pick. It's the same means test over and over and the same result.
Correct. It's just when we say discretion, if you have a mortgage payment of $2,000 a month as opposed to a mortgage payment of $1,000 a month, they're both are going to be allowed.
Okay,
it's just that the means test is the same means test throughout the country, no matter what lawyer, what judge. It's a federal statute.
Okay. So my next question would be that not all assets are considered. Is that correct? Are there some assets that are exempt from bankruptcy?
Yes. And if you live in the state of Florida, we have different exemptions than we use the Florida exemptions as opposed to the federal exemptions.
Okay.
In other words, your homestead, if you qualify for the homestead, and people get confused, there's two homesteads in this state. There's one homestead as far as when you pay your taxes, you get a homestead exemption for a certain amount of dollars. That's not the homestead I'm talking about.
Right, you're talking about our constitutional homestead protection.
Correct.
Okay.
And if you've lived in that house for it's a little less than 4 years, then your entire proceeds are exempt. That's one exemption. IRAs are exempt. Certain pension and profit sharing programs are exempt. Annuities are exempt. This as long as you don't transfer money into these items prior to the bankruptcy and say, well, I'm going to file bankruptcy, I have these exempt assets, and therefore I can go scot-free. There's fraudulent transfer statutes that avoid that.
Right, clearly. Are there any contingent assets that are part of, like if you have a pending lawsuit, or if someone is paying you back money that they owe you, or if there might be an inheritance coming?
If you go bankrupt, you have to list pending lawsuits. If you have a personal injury case, you have to list it. That belongs to the bankruptcy trustee. Now, many times the debtor will make an agreement with the trustee to continue with that lawsuit, and the debtor will receive some monies from the lawsuit. Most of the monies will go to the bankruptcy estate to pay creditors. There's one provision under the bankruptcy code that says if you file a bankruptcy, you are within 6 months from the filing of the bankruptcy, if you inherit money by way of a will, life insurance, or from a marital settlement agreement, that money comes back in to the bankruptcy estate and goes to the trustee.
Okay, so I hope you're listening. I'm going to have him repeat this. This is probably the most important tip that Charles is going to give us today. Repeat that, please.
If an individual or a couple file a bankruptcy, and they, within 6 months of the date of the filing, they inherit money by way of a gift, by way of a will, a bequest, or a life insurance policy, or receive money as a result of a marital settlement agreement. In other words, that they signed an agreement prior to the divorce, and all of a sudden one of those assets are split, and somehow they receive money. Within 6 months, that money comes back to the bankruptcy trustee. Okay,
so that's very interesting to think about. When a couple files bankruptcy, is there a tax ramification?
Generally, no. It depends on when they, and this is too complicated in this short period of time. There is not a tax implication. Some of these short sales that are going on today, if it's not a homestead and there's a short sale, there's a 1099 issued, but if you file a bankruptcy, it's a presumption of insolvency, and there will not be, you will save the taxes.
Okay, great. That's really important. A lot of properties right now are backwards, upside down, and going on a short sale. If our audience wants to reach you, do you offer a free consultation?
I do.
Okay.
Especially if they mention this program.
If you mention Divorce Connection Network, Charles is going to give you a free consultation for family law. And if you have any bankruptcy questions, he'll be more than happy to answer those for you as well. How do they reach you, Charles? Please tell our audience.
I'm in Boca Raton at 2255 Glades Road. My phone number is 561-395-0500. Just ask for Charles Cohen.
395-0500, ask for Charles Cohen. We'll be right back.